I was working off
Good morning.
Hour. Good morning.
Good morning, Miss Bergerman. How are you?
I'm here, and that's the best news.
I have an Augustine Atani in the Zoom room. Are you able to connect audio, sir?
Hello?
Hey, good morning. What case are you here on?
The case number you need?
Yeah, what case?
A divorce hearing. It's DR 000884 dash FFM01 dash XX.
Okay, I don't think that's here today. Let me look up your case. I apologize, Miss Bergerman. Hold on one moment.
Not a problem at all, Your Honor.
Can you tell me again the case number?
Case number is
Something out.
11 dash
You can pick it up off.
2021 dash DR dash 000884 dash FM01
Okay, I got it.
XX.
Okay, that's McGowan's case. That's Judge McGowan. So you're in the wrong Zoom room. You have to go to Judge McGowan.
Oh, okay.
Okay. All right. Do you understand?
I understand.
All right. You're being divorced today. You're getting divorced today. So get in there as quickly as possible.
Okay, thank you.
Bye.
Bye-bye.
Okay. We're here today on the continuation in Orel versus Orel, 19DR 1212. Please enter your appearance, Ms. Bergman.
Vera Bergerman on behalf of Stephanie Orel.
Okay. I do not see Mr. Orel in the waiting room. Ms. Bergerman, have you heard anything from him?
Oh.
I mean, let me.
Oh, have we heard from Mr. Orel? Mr. Orel is taxing my patience sorely, Your Honor. He does apparently, he's issued his own notice of trial for a motion to amend support, a motion to compel wife regarding parenting time, a motion to compel wife regarding release of lease pendants, and a motion to compel wife regarding bank statements. And he has a hearing, but he calls it notice of trial setting, June 28th at 9 for 90 minutes. And maybe he thinks that this is his next go around. But my client, Stephanie, she may have more information.
Okay. I'm not going to put her under oath yet.
Okay. Have you and David spoken at all regarding the fact that today is our trial day?
No.
No. Okay. All right. Can you come a little bit closer here? That's okay. Yeah.
Do you have his contact information that I can have my JA give a call?
Okay. I have him at 239-331-0775. That's correct, Stephanie? Okay.
Okay. Let me have Cheyenne try and give a call. Please wait up in the waiting room.
Okay.
Thank you.
Mhm.
Ms. Bergerman?
Yes, hello.
Hi. We haven't been able to reach him. The phone number has some sort of message on it saying that his phone is being repaired, and he's not. Something like his phone is being repaired. So anyway, he hasn't answered.
Your Honor, can I inform you of what has happened from a procedural standpoint since
Yes,
our
please.
last hearing?
Please.
Okay.
Yeah. By the way, this is now the time where it was trial. We are. The time is 9:28 according to my clock, and the trial was set for 9. And Mr. Orell is not here and not in the Zoom room. Please proceed, Ms. Bergerman.
Okay. Your Honor, as an officer of the court, what I am telling you is the truth as I know it. Okay. And I will begin with our date of last hearing, which was the
20th.
21st of, I believe that was
April.
the 21st of May. Yes. And on the 21st of May, we had a status conference. And at that time, that was also the day that you entered the most recent order in this case. And in that order, you had provided that, and you apologized for entering it late. And you said you were sorry, you did not mean to interfere with the closing date for Mr. Orell's house. So, and you also provided for the a procedure whereby Mrs. Orell was to get a sheriff's deputy. Mr. Orell was to pay for the sheriff's deputy. She was to go to the house with the sheriff's deputy and retrieve whichever of the children's items was appropriate, as well as the children's memory boxes, which Mr. Orell said he could not find, her grandmother's plates, and Christmas ornaments. Okay. So, and we had also relayed to you that Mrs. Orell had made contact with the Family Resource Center, and we had reported back at the status conference that both parents had to go through their intakes and then things could begin. We also reported that Mrs. Orell had contacted Mary Shorak's office and that they believed that the week after next or something to that effect, the parties would be able to get in with something with Ms. Shorak, but that her husband was in the hospital and her schedule was somewhat erratic. And that we were going to begin the Zoom calls right away. That's where we left it at the, and that I had gotten out the lease pendants after, again, we received the order. So that's where we left it in the mid-afternoon of May 21. So the first thing that happened after the status conference was Mrs. Orell and I got busy with the Sheriff's Department in Collier County to find out what their requirements were. And one of the things they required was like a certified copy of the order that talks about their office being involved. So I worked very quickly to prepare the order from the status conference. And I believe you have that. Is that correct, Your Honor? Do you have that order that I prepared from the status conference?
The order for walkthrough from the Merrill home?
Yeah.
Yeah, it was issued on the 25th.
Okay. So, right. I got that in just as quickly as I could. I ran it past Mr. Orell again, but that I was met with a barrage of personal vitriol against myself. But anyway, the most important thing that happened that day, I think, was that we sent the release of lease pendants to the title company that was handling the closing. Okay. And that was a Tracy Townsend from Townsend Title Insurance Agency in Cape Coral, Florida. And I had gotten her name from in an email from Mr. Orell's attorney, Matthew Flores. Okay. So the Townsend Title Company got back to me immediately with a revised HUD statement. And on that, it provided for the $100,000 to be set aside for Mrs. Orell in my trust account. So after I received this, because it appeared that the closing was still set for the 21st, I called them and I said, I am in receipt of your HUD 1. And you are in receipt of my lease pendants, release of lease pendants. Yes, yes. I said, well, what is the new date of the closing? And they said, but it's today. And I said, well, okay. I said, Mr. Orell had told us it was postponed for a week. And Mrs. Orell has to go get her things. And it appeared from our status conference that there were still many boxes in the house. And there was this long pause. Then they brought someone else from the title company on the phone. And they said, they seemed rather dumbfounded. And they said, what are you talking about, Mrs. Orell? They're divorced. I said, no, they're not. And they said, well, he said they were, and we have all the papers prepared for him as a single man. I said, well, I'm sorry for you for that, but what else? What else is going on? They said, well, he's been behaving erratically. Those were their words. And he has not allowed the buyers to have a walkthrough. And the buyers are upset with them, and I think they're probably not going to go through with this transaction. I said, oh, well, then it was my turn to have not much to say. I said, well, please keep me informed. So the next thing I know is Mr. Orell sends over a notice of termination, and with a note that says, party's over. Those are his words. Party is over. And
notice of termination of what?
The termination of the contract for sale of the home. So I thought, well, it's one thing to have a termination, but you have to have both parties sign the termination. From my memory of the way things work. And sure enough, there was Mr. Orell did sign the termination. And now there is no closing on the house. His lawyer will not return my phone calls. And Mrs. Orell is still without any support. No, she's borrowing a vehicle from a friend. He's sitting there with judging from the HUD 1. He has apparently gotten a forbearance on the mortgage, like people throughout the country were allowed to do in 2020 and continuing onward. And I based that on the amount of the mortgage payoff that was listed in the HUD 1. So he's sitting in his house, not paying his mortgage, not selling it. Mrs. Orell has indeed gotten going with the phone calls for the FaceTime. She has the children in their room with the door open, and she is in another room. So she gives them privacy, but she can still hear in the event that anything inappropriate occurs, as it did previously. So she has heard him telling the children about, the work he's doing and big things he's painted, things that kids would find interesting. They have gone to the Family Resource Center. They have had a visit over there. The children apparently enjoyed it. And Mrs. Arell had alerted the director of the Family Resource Center, Carmen Rodriguez, that he had had issues before regarding appropriate communication. So Carmen especially focused with him on the rules of their center so that he would be well aware and could, not have any problems as he did previously. And one of them was that he could not bring presents. So, but he did bring pictures to show them, which was nice. And they enjoyed it. Unfortunately, Mrs. Shorak's office still has not been able to set anything with Stephanie, and that's I don't have anything more from Mr. Arell, and that's where we sit today.
So what's the status of reunification therapy? Has it even begun?
Not yet. I haven't heard anything back from Mary Shorak's office yet as far as getting on their schedule.
But they are having their time sharing.
Yes.
The time sharing being the supervised and the FaceTime?
Yes, sir.
Okay. It seems apparent Mr. Arell's not showing up. Ms. Bergerman, what's your suggestion for how we proceed today? I mean, part of me, I'll just tell you, part of me would like to continue this to let reunification therapy go while keeping everything in place that we have now. But I'm concerned, obviously. I'm concerned about the behavior. I'm concerned about what I can interpret from the behavior based on a number of erratic motions filed with the court. And I'm concerned because he seems to be making decisions out of spite. But those are my concerns right now. What are your thoughts?
Well, Your Honor, on top of everything else, we have, as I have no doubt Your Honor is aware, we have a new Florida Supreme Court case that came out April 29th. And that is the CN, just the initial CN petitioner versus the initials IGC respondent. And this is a case that we have all been waiting for years, quite literally, which, and the issue was whether a final judgment that modifies a pre-existing parenting plan must give a parent concrete steps, quote unquote, to restore lost time sharing and return to the pre-modification status quo. And the Supreme Court of Florida held, we hold that there's no such requirement. Now I realize
there's no parenting plan.
We don't have a pre-existing parenting plan. But it will be, it's interesting that the only pre-existing parenting plan we had was a temporary one. That was it. And it was to use the term modest is an understatement. It was the supervised parenting time and the FaceTime. But I think that in the best interests of these children, which my client has been long suffering with Mr. Arell because of the best interests of the children, I think that we need to continue our work with the reunification. As difficult as he is for us to deal with, he is nonetheless their father and he loves them. I
love hearing that, Ms. Bergerman and Ms. Worrell. Thank you. Thank you.
Well, we appreciate your sensitivity, Your Honor, in trying to deal with this whole situation. We think that Mr. Arell really does have a problem. I mean, we know he has a physical problem, and I think he alluded to it even, and we did.
That's the brain tumor?
With the brain tumor. I think this could very possibly be a part of what causes his erratic behavior. But
let me ask this, and Ms. Arell, you're not under oath.
Okay.
Was his behavior similar when you were married, or is this new?
It was similar, but throughout the years it has gotten worse.
Okay.
My concern, Your Honor, is that many times, and I don't think I'm saying anything that the general public wouldn't know, people with issues that plague them emotionally, mentally, will self-medicate. And Mrs. Arell would testify that he would self-medicate through the use of some legal and some illegal narcotics. And that was one of the reasons why we had the drug testing provision in there. And again, we were concerned because it was he waited about a year, was it?
Yeah.
To get the drug tests done. And Your Honor, we asked to have him drug tested again, and Your Honor specifically considered that and made your ruling, and you said no, he does not have to. But I am concerned now. I mean, the communications, the erratic behavior. I think there's a possibility. Now, as long as, again, he's seeing the kids in a supervised setting and the FaceTime, we have no concerns as far as that goes. But I think everybody should be on the same page if he is using drugs. I mean, I think what we all would like would be if he could get properly treated to help him.
Yes.
Certainly, and this whole, so that's that part of it. And then the other
one thing I do want to tell you is that I think we're in the last 2 weeks of Zoom hearings.
Oh.
So one thing that will happen when if we do continue this is that it will be in person, which may be a little bit more helpful in this situation.
Oh, okay. Oh.
I didn't mean to cut you off, but I do see where you're going.
Mm-hmm.
And I wanted to let you know that is probably coming down the pike very soon and may be helpful.
Oh, well, I had not heard that, Your Honor, and I do try to, keep involved with things with the bar, the local bar associations, etc. So that, do you know if this is just for Collier or for all of the 20th Judicial Circuit?
All. I think, yeah, and it's going to be kind of based on, I think, judge by judge, how we're going to get back into in-person. And I know this doesn't concern you as much, Ms. Orell, but part of the reason is that things tend to operate differently when we're in person.
Mm-hmm.
And it may be beneficial in this situation.
Yes.
I expect that we're going to be resuming full operations, I think, June 21st.
Oh, my goodness.
But,
okay.
But that's not final yet, and that may not be for family, and things that are set on Zoom are going to probably remain on Zoom until we run through that.
Okay.
But that being said, the trial dockets coming up, likely in person.
And Your Honor, I'm also concerned because my client has had no support at all, not her tiny alimony amount, not her child support. She's taken over, the children's health insurance, which is at a very modest cost, happily. But she pays for everything with the children with no assistance whatsoever from Mr. Arell. You know about what happened to her car, and now he's not selling the house, and I don't have a partition action because her name is not on the house. And the way they had run things was, they were together for years before they got married. You heard about how they had their
Both children.
Actually,
both
guess
children.
what? Guess who just joined?
Oh,
Hold on one moment.
okay.
Good morning, Mr. Arell.
Good morning.
You're about 50 minutes late.
Yes, sir.
What's going on?
I have no excuses. I was sleeping.
Okay. Pretty important date. It's trial date.
I understand.
All right. Can you put your video on?
I'm trying.
Okay. Before you were there, I was discussing with Ms. Bergerman what has occurred subsequent to this court's orders. Some of it good, some of it not so good. She reported that you are now having FaceTime calls with the children, and those seem to be going well. She also reported that you've continued with supervised time sharing at the what's the place, the Children's Advocacy Center? Is it Advocacy Center?
The Resource Center.
The Resource Center, and those seem to also be going well.
It went super well. Yeah.
Okay. And she's reported that, what else? You guys haven't been able to begin the reunification therapy yet, but that
correct.
seems to be an issue that is scheduling with Mary Shorak, which is something that I think the court thinks needs to happen, has got to happen as quickly as possible. Ms. Bergerman also alerted me to some other issues that aren't as positive, at least relating to the house and things like that. Can you, Mr. Arell, and I'm not putting you under oath yet, because this is right now not as much as a trial as is a conversation.
Okay.
What's going on since the last time we met? In my order, the order I issued continuing this was issued on, let me see. I was late on it, but I issued the order granting the continuance on May 21st. What's happened subsequent to that order?
Well, the order was to proceed with the sale, and we no longer had a sale. The buyers had canceled. So I had submitted the termination of agreement. And now we're sitting here with nothing going on. We don't have a sale. We don't have a buyer.
Why did the buyer cancel?
They listed numerous reasons on their paperwork, everything from drywall to repair related. They wanted a new AC. It's all in the order.
Okay. Is the home still on the market?
No, sir.
You took it off?
Yes, sir.
Why?
Well, because I figured that this Liz pendants was inhibiting me quite
Liz pendants
exponentially.
is gone.
I don't have a release, and it's on the court
released.
records.
It's been released.
It has?
Yeah.
Good.
Yeah. Very well. What was the date of the release, Ms. Bergman? Or it has been-
We sent it, it was the 21st, Your Honor, and we sent it to the Townsend Title Agency. And again, we received the HUD 1 that was due, and again, it was supposed to close. And they were awaiting Mr. Orell to allow the buyers to do a walkthrough.
Okay. Do you plan to put it back on the market, Mr. Orell, or no?
Of course. Yeah, that was my plan all along.
Okay. What else has been going on, Mr. Orell, since May 21st?
No significant changes whatsoever. Trying to get myself motivated into a new industry, low voltage. However, I don't have much drive, and moreover, I don't have any finances whatsoever to work with. It's been very difficult. Therefore, I'm just trying to maintain day by day. I spend most of my days on the computer learning law and court proceedings. However, it's so ambiguous when you read it without any type of teachings that it's very hard to understand, and it's very hard to know.
That's why people get lawyers.
Yeah. In my situation, having been through 3 lawyers, over $60,000 worth of spent money, and me nowhere in sight of having my children back, it's disheartening. I don't know who to trust. Lawyers, when they talk to me, they say they're going to do one thing, but they never follow through. So trust is a big thing with me, and I haven't been getting anywhere whatsoever. I had a meeting with Mr. Chandler. It was a very positive meeting. However, he wanted $5,000 down. I told him that I don't have $5,000, and if we can get through the sale of my home, then I would have the money to pay. However, he needed some money down. I have a lot of bills that are late. I have several summons. I said I'm going to submit 2 today, one from Discover and one from CarMax. They're suing me. So I'm
late
in
payments and things?
Yeah, I'm in debt.
You're sitting on a big answer.
Yeah, I tried to follow through with that answer. However, having $100,000 taken away from the sale with no respect to the amount of debt or anything else that's needed to just take $100,000 of my wealth.
It's in escrow. It would be in escrow.
I understand, which would not able me to pay any debts, my student loans or anything else. It would just be taken right off. And if I know Mrs. Bergerman, I know that she'll find some reason why she needs the $100,000.
Then you don't know Miss Bergerman.
How much does she need then?
We have orders that were what you had needed to pay. The temporary orders were in, and they are in arrears. That's part of what the money was for. The other thing was for potential what you would need going forward.
Right.
We could tell that there'd be finances available even after that $100,000. Certainly $5,000 for an attorney. We're floundering here, Mr. Orell. We're floundering. You need an attorney. And we know you need one. I'm concerned about going forward today in trial for a couple reasons. One is because I really want reunification therapy to happen.
Me too.
And it has not occurred yet. And part of that is on the court for not getting the order out in time as quickly as I would have liked to following the continuation. Part of that's just the circumstances of trying to get in with Ms. Shorak. But
I think that's what
my number one priority is looking out for the best interest of the children. And a couple things come to my mind. First of all, the best interest of the children are not served by not having a relationship with their father. And we wanted to get them back into position to have a relationship with their father. But also, the best interests of the children are not served if I can't be assured that the children are physically and mentally safe with the father. And I'm concerned. I have lots of concerns going on right now about what's happening with you, Mr. Arell, about, even some of the filings that have come across. I understand you're frustrated, but they're also very, I don't know if I'll use the word erratic. Are you currently, what's going on with you? And again, you're not under oath, and I'm not trying to pry, but are you okay medically right now?
I don't know. I'm not a psychiatrist, nor have I seen one. So I don't know.
Do you feel like you need to?
Well, who can self-diagnose themselves? I know that.
I know it's hard, and I'm happy to order one for you if you think it's helpful. I know that doesn't necessarily solve any problems, but it's something that could definitely help me be more assured that once we get to the point where we're looking at the best interests of the children, that you're okay.
Well, I believe I'm okay responsibly, but if I can't wake up when I know I have court, when I sleep like a rock, and that's probably not healthy at all. I don't know what that means. But I do know that my sleeping patterns for the last 2 years have been like this. I've slept through a lot more than court.
Well, I'm not a medical doctor, and I'm not a psychiatrist, but I do know that that's a symptom of some things.
Yeah, me too. I agree.
Here's what I'd like to do today. What I'd like to do is to continue this trial, to require reunification therapy to happen. And I can't make Mary Shorak do something that she doesn't have time for, but
I've called her.
I would like to get back to the reunification therapy. I would like to order you to have a psychological evaluation.
That's fine.
That's fine? Okay.
If that's something that you think would help you and respondent's party, I
think not only would it would help me,
like that.
I think it would completely help Miss Orell as well, as she does have concerns about the safety and well-being of her children, as any mother would, and very understandably.
Yes. I agree.
So here's some of the other issues. Obviously, on the financial side, a lot seems to be riding for you personally, and in this case, on getting this house sold. Still a great time, still a great market where you can do that.
Agreed.
There's nothing that I can do right now that's ordering you to do that. So I'm not going to be ordering you to do that, but just so for the court's benefit, is that something you're still planning on doing?
Of course. That's something that would put me in the position to be able to capitalize on all my other opportunities that are out there. I cannot do anything with no finances. As I say, it takes money to make money. And when you're absolutely broke.
Hold on 1 second, Mr. Arell. Ms. Bergman?
Yeah, Mr. Arell, I don't know whether you know or not, but I had gotten from the title company a statement. They prepared it after I sent them the lease pendants, And they also had the order that provided for the 100,000 to sit in the trust account. Did you know that you were going, after after the 100,000 was set aside, after your mortgage was paid off, the closing costs, the realtors, you were to get $259,950.67. That's how much was coming to you after all those things were paid off. Did you know that, Mr. Arell?
And this isn't a question. This isn't an examination because we're not beginning a trial.
Yeah.
It's just something that Ms. Bergman has seen from the HUD one. Obviously, that's a lot of money, and it does nothing even to do with the escrow, which you may or may not be getting a portion of that back. That's
Right.
just something being put aside. Clearly, that would be enough to pay a retainer for Mr. Chandler or many other attorneys. Mr. Chandler has appeared before this court numerous times, so we've
That's what I've heard.
we've met.
And I work
Referred to
very
me by-
well with
by
him.
several people.
Yeah, I work very well with Mr. Chandler. We've settled many cases together.
So here's what I'm going to do, I think. And it is still up for a little bit of discussion, is I'm going to ask Ms. Bergman to prepare an order continuing the trial, reiterating the need for reunification therapy, but also ordering you for a psychiatric evaluation per agreement, as it doesn't sound like you're questioning that within, I think probably within 30 days.
It's fine. You can even make it sooner if you'd like.
I would love to make it sooner. I just want to give you the outside. It would be great for you to go even quicker than that.
I'm prepared to do whatever the court needs me to do.
That's what I love to hear. Thank you. Because again, I think you're starting to recognize our goal. Our goal here is a safe and good reunification with you and the children. That's what we're trying to do. And we just need to get there. So I guess the question is, who do we have do this evaluation? Ms. Bergman, do you have any ideas of people we can have?
Yes, I have two ideas. One is there's always the David Lawrence Center. I don't know what their availability is. And I also am not certain about the whole pricing thing, because again, the other thing I want to address as well is, again, Mrs. Arell being able to get those items out of the house. It sounds like we're not under the gun for 3 days like we were previously. But I'd like that to happen. But Mr. Arell,
let's focus on the psychiatric.
Yeah. Oh, sorry. I'm again, but it goes to the issue of money. There is Dr. Warren. No, he's not a psychiatrist. He's a psychologist.
They are different, yeah.
Wow.
Well, how about this?
Just David Lawrence Center.
And that's probably a good option. Is there any issue with that, Mr. Arell?
No, Your Honor.
Okay. All right. So prepare the order for the David Lawrence Center.
Okay.
Okay. Let's talk about this. Let's talk about this walkthrough now. I understand that it hasn't happened yet, even though it's been court ordered. Mr. Arell, what's going on with that? Why hasn't that happened?
Well, there was a concern about after she had gotten the Liz pendants approved, after you had signed the order, that she was going to come here and lay claim on just about anything that she wanted. Therefore, I had concerns of her coming here and laying more claim on even more things and creating even more hardship for me. The items of personal belongings that she had requested, I had proved to the courts through pictures that she had already received. Therefore, it felt to me that it was just a an invasion of my civil rights and privacy, trying to come here and looking at what I have left. Mrs. Bergman writing an itemized list of inventoried list of my personal belongings so she could then have a better idea of my total assets, because that's what it feels like to me is money. It does feel like the reunification of my children to an extent, but moreover, it feels like a continuation of the respondent trying to.
I can see how you feel that way. I can understand where you're coming from. And I think if we were if somebody was in your shoes, they may feel like that's the same thing. But I can guarantee you two things. One, that's not what's happening here, because whatever the personal property is has zero to do with any type of other financial issues going forward or going backwards. Two, the things that she's listed are very personal, memorable type items, nothing of any significant value to anybody except for her.
That's correct.
So
the pots and pans
cannot possibly be being utilized as a tool. Number three, and here's where you get sideways with the court, Mr. Orell. This was already put in an order by the court, and the orders mean something. Once they're in writing and it's an order in the court, it's not toilet paper, it's an order, and it needs to be complied with.
I didn't have even a couple of $100 to hire the police department to come here to supervise like Mrs. Bergman requested. I don't understand why we have to involve the police.
Because of the injunction. Because of the injunction.
The injunction creates a lot of hardships.
I agree. It does create it. I'm not getting rid of it right now. We haven't gone through a trial yet. It is something that's going to be considered, once we get to the trial stage. But as of right now, at this moment, the injunction's in place. I didn't put it there, but it's in place, and it is a court order, just like I was saying before. And that's the reason why. Ms. Bergman, how much, because we're in touch with the sheriff's office, how much are they asking for the walkthrough? And is that something that you're willing to front right now? As we are likely going to be getting money in escrow.
Well, Your Honor, we might have been willing to front it, but
my order.
But then Mr. Orell's words were the party's over. His exact words in writing regarding when he terminated the contract. He terminated the contract. It took 2 signatures.
Yeah, no, so, I got that, but I also want to be reasonable with the fact that it does seem like we're having some sort of psychological issues when Mr. Orell believes, rightly or wrongly, and the court's saying it's wrongly, but I can understand from Mr. Orell's position that you're trying to, and I'm using Mr. Orell's words, extort or extract something for the children. So it does seem to be a trigger for him. But what, just so I know, how much money are we actually talking about for the sheriff to do? I can't imagine it's a long walkthrough.
It was, no, but they said based on the domestic violence injunction, again, this is what I was told by the sheriff's department, they were going to send 2 officers, but they weren't going to charge for 2 officers. They were just going to give us an extra one.
Okay.
But they felt it was needed. 200 and, was it 275 or 2? It was over 200 and under 300. Correct. It was between 200 and 300. I think 275 comes to mind.
Okay, so call it 300.
All right. Are you able to pay that now, Mr. Orell? Do you have 300?
We'll pay it now. Yes.
Okay, good, because
if that's something that needs to happen.
Yes.
That can happen. I think I did find her memory chest that she was talking about with the baby blankets. I did find Brianna's and Brandon's. So if that's something that she's very partial to, I have those items.
We've
that I
had
can send
we've
pictures.
had 3 court hearings over it, so I would say yeah.
Mhm.
Well, I was
Yeah.
looking for mailboxes. I wasn't looking for plastic bins.
Okay, perfect.
I have
All right.
100 plastic bins
So,
here.
so, so Miss Bergerman, we're gonna keep we'll basically, you're gonna update the order just for a new time for this walkthrough, but everything else will be the same. Can we schedule that right now while we're here? I don't guess I can't because the sheriff's office is a necessary party.
Right. That's, yeah. But we can
Within,
put in the order that it can be completed by a certain date.
yeah.
A
That
week,
would be good.
2 weeks.
Can we do by close of business next Friday, or is that too?
Are you able to adjust your schedule?
I might.
Well,
Maybe.
she doesn't have to need to adjust. We can. When would she want to do this? When's good days?
Weekends are.
Weekends are?
Yeah.
Oh, I think we were getting on-duty officers, but they work on weekends too. Weekend? What weekend day?
We'll do a Sunday, or we'll do Saturday
Saturday
can
or
do
a
it
Sunday?
after their visitation on Saturday.
Can I request that the children come here as well, not just the mother?
Not
That was
yet.
a concern of mine. Why the children have not been to their home, the only home they have ever known since the May 1st incident. And I've brought this to the court's attention numerous times, and I can see that Mrs. Bergerman's physical attributes right there totally contest the children ever coming here. And I don't understand why the children coming here to look at their belongings are so important. The children have.
That's Mr.
reasons.
Rell.
Mhm.
See, that's completely not the case. We understand that the children haven't been there. That's as a result of the injunction and the temporary thing. However, as I've reiterated to you, our goal here is reunification without supervision. And they will be able to come to whatever house you're living in. Once we get to that part, that's going to take place after the trial in this matter, and after we can assure that you've gone through reunification therapy, or the children have, and you, and that we can be insured about your mental health. Those are the two things that need to happen.
So
Ms.
what is
Bergman's all on
why
board
is the
with that.
walkthrough so important then? Why are we spending time on the walkthrough when we have amend of temporary
'Cause we can-
spousal support and
we
we
can-
have all these orders to go through? We're talking still about coming here and laying claim.
Because we can walk and chew gum at the same time.
We should be able to. Yes.
Yes.
I agree.
So I guess, are you seeking to do it this weekend, Ms. Bergerman? Or because I wasn't clear when the supervision was happening, or
Pick a day, but again, we've got, okay, we are on Wednesday. I think this is too short of time for the,
so in
for the
your
sheriff.
order, have it done by close of business, not next Monday, but the Monday after. That will give her the opportunity to do it any of the
Okay.
weekends, either this weekend or next weekend.
Okay. All right, by close of business, I'm just looking at the calendar to get the proper date.
But please recognize, Mr. Orell, it's going to be on one of the weekend days.
That's fine.
Okay, all right. So next, okay, we are here today on the 9th. So next Monday's the 14th, and that would be by June 21st then. Okay, by close of business on 6/21. Okay. All right, wife will choose day and arrange. Okay. And I guess as long as, again, we're still talking and no one can make Mr. Orell do anything anyway. Two other things I'd like to talk about is when he intends to put the house back on the market.
I think he said immediately, but what is that? Is that correct, Mr. Orell?
Yeah, it's ready to go. I mean,
Okay.
the only thing I have done is start a pool renovation that needed to be done, and I can finish that up in the next day or so.
Are you going to be listing with the same agency, Mr. Arell?
I was planning on it, yes.
Okay. Could we have Mr. Arell provide us with a copy of his listing agreement when he does it, just so we're aware?
I have a listing agreement already.
Okay, would you mind sending it to Ms. Bergerman?
Sure.
Okay, wonderful. It's going to be in the order too, but you're going to have 3 days to send it to her, and you can just email it to her.
That's fine.
So that's an easy compliance.
Decent.
Okay.
How
I'm
about
going to talk to I want to put this, I want to keep track of this because I want to make sure I'm following everything that's happening here. So I'm going to ask Cheyenne while we are talking to get some dates, potential dates for a case management conference, hopefully within a month from now.
Your Honor, I have, I would also like to, I'd mentioned earlier, Mr. Arell did a notice. He called it Notice of Trial Setting, and it's June 28th at 9 o'clock, and he has 90 minutes, and he has 4
Okay.
Motions.
Perfect. Then we'll be able to talk about it at least during the course of that time.
Yeah.
That'll be a good time for us to also check in and see what's going on.
I was under the impression that we were going to go hit a couple of those points today because the support in which respondent's party has in temporary orders with this injunction is not in line with neither of our long forms, nor has she given me the burden of proof of why she needs so much financial support with the monthly obligation financially and also the Liz pendants. She has
I've reviewed your motions, Mr. Arell. It's not before the court here today, but those are the types of things where if you had an attorney, it would be much more beneficial for you to understand what it is that you're stating and why. Like, it'll be much more beneficial if you had an attorney for something like that. Here's the exercise I want to do right now, because I think this is important. Mr. Arell, it's not apparent to me that anyone's ever read View of the Factors that the court needs to look at when determining parenting time.
no,
But there's a statute.
Okay.
There's a statute. It's 6113, Florida statute. In
6113?
Yes. Part 3 of that statute lists the factors that the court is commanded to look at when determining parenting time. A couple of them are pretty important, especially in this case right now, that I think will be very useful for you to consider. One of them is the mental and physical health of the parents.
Okay.
That's why we want to do the psychological evaluation, so we can be assured.
I have no problems with that. Yeah.
Yep. Another one is,
Another factor is the domestic violence.
Yeah, but even more important for going forward here with Mr. Arell is the factor that I have to be assured that whatever schedule or whatever orders are going to be complied with, especially as it relates to time sharing with the children. And part of that goes to the conduct that I see during the course of the litigation as far as compliance with different, court orders. I'm trying to figure out which is the actual number of factor on that one, but it's not really providing
A path.
Oh, yeah, but it's. Oh, that's A. The demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. I know right now you haven't had any time sharing for a little bit, But one of the factors, honoring a time sharing schedule is important because time sharing schedule is a court order.
Right.
So compliance with court orders and how you are doing that how you are going forward is essential in at least the very first factor that I'm going to be considering. You can read all of these factors yourself. I don't know if this is a useful exercise or not, but it's Florida statute 6113. And it'll help you understand, even if you don't end up with an attorney, and I really hope you do, if you don't end up with an attorney, it'll understand that what I'm going to be looking at, and maybe it'll help you act accordingly.
I do remember what you had just said, that paragraph reminds me of the parental responsibilities worksheet that we had to complete for the parenting schedule. That sounds like it's exactly like number one, and I had submitted that to the courts as well.
Okay.
My side, anyways, the father's side.
Good.
And I listed answers to every question on that large application.
All right. Well, excellent. We're going to, we'll talk again as far as scheduling is concerned on the, what's the 26th, Ms. Bergman?
The June 28th, where
June 28th, yeah.
again, there are, so Your Honor, do you want me to do an amended notice of hearing? And so that would then have the status conference added to that?
I don't think you need to do an amended notice because they're just going to do a status conference for it. I'll be doing it. I'll remember this. This is going to be a case that I follow. But if you want to do an amended notice that includes a status conference on that date, that's fine. It's not going to take up any additional time.
Okay, because some of again, Mr. Orell has 4 motions, and again, like his motion to amend support, that would be dealt with at trial if we could ever finish this trial. You would be determining what the appropriate support is.
I understand.
Yeah, that's
I understand. That's why it's
That's a
important for us to
concern.
get to trial. But I don't want to get to trial the wrong way. I want to get to trial in a way that we can actually properly assess time sharing. Okay. Ms. Bergman, is there anything else that the court needs to do today, or do you have any questions with regards to the order?
Okay, I just want to, again, if we could go over what I'm going to have in here.
Yes, please.
So the parties will continue with the reunification therapy.
Can we put some timelines on that somehow?
Do you think perhaps we should try another,
Another avenue?
another practitioner?
If you can't get in with Mary Shorak,
Yeah, she's not
within the
calling
next
me
couple of
back at
weeks,
all.
let's get another reunification therapist.
That's
and
a good
Ms.
idea.
Ms.
I
Bergman,
think
do you
so,
have
too.
anyone else in mind?
The Family Resource Center offers it.
The Family Resource Center offers it?
It was on
Yeah,
Oh,
Oh, really?
I like that place.
and they're already going there, so it would
Okay.
Right.
That sounds
It's
that sounds
convenient.
amazing. In fact, if you want to do that instead of Mary Shorak, that'd be great, because the sooner this happens, the sooner we can get to trial and the sooner we can bring finality. So
Agreed.
Okay, parties will, I'm going to put here then, initiate reunification therapy through
Family
FRC.
Resource Center.
Yep, Family Resource Center, well familiar with it. Family Resource Center, not Mary Shorak. I'm going to put that in there in case there's any doubt about it. Mr. Orell will obtain a psychiatric evaluation per agreement within 30 days through the David Lawrence Center. Or he could go or
At the Family Resource Center as well.
no, this is a
I don't think they do that.
Yeah, okay,
Yeah.
I got my doctor's.
But I don't want to limit him to David Lawrence Center if he finds another psychiatrist
Exactly. If I could just get one completed.
or any other psychiatrist.
State licensed, that's all we need, right?
Yeah, well, yeah, we don't want to telehealth.
No.
I do
Yes.
want whoever it is. All I want is a notice with the court telling me who it is. Filed.
Okay. Notice of who? Okay, notice of who psychiatrist is. Okay. Licensed psychiatrist. an in-person appointment. Okay.
With the evaluation, I do want it to be submitted to the court after it's completed, but only to the court.
Submitted to court.
Do you understand that, Mr. Orell? Meaning it's not going to go to Ms. Bergerman
I
and Mr.
understand.
Orell.
Yeah,
It's going to go to me
that's
in
fine.
camera.
I'm
In
going to
camera
put
just means.
to
yeah.
judge in camera. That means, Mr. Orell, don't actually file it with the clerk.
Yeah.
You have to physically get it over to, well, physically you could send it via email,
Yeah,
but it goes
judge's
only
assistant.
to Cheyenne. Okay,
Understand.
not the clerk, not me. Okay. A new time for the walkthrough by close of business on 6/21. Wife will choose the day and let Mr. Orell know so he can pay for the sheriff's a listing agreement to be sent to Attorney Bergerman within 3 days of.
Can we go back to the supervision of the police department? Are you going to handle that financially?
It's
Can
in
you-
the, it's
if you
in the,
need
it's in the
supervision, can
court.
you get?
Mr. Orell, it's already been determined in a prior court order
I
that
understand. Okay, fine.
is used, so it's going to stay.
I'll put $300 aside right now for it.
Good.
Okay.
Excellent.
And then we're going to add to the hearing that on June 28th, there will also be a status conference.
Agreed.
Okay. Now, then I guess we're going to actually have a trial continuation date as well. What happened to Mr. Orell? Oh, there
I'm
he is.
sorry.
Okay.
Yeah. I'm going to work with Miss Sheppelrich and figure out where to put this on a pretrial docket. Part of me wants to wait until we have the status conference because I want to see if reunification has started and how is it going. And then based on that, we might be able to decide that we can set this for a quick turnaround for a trial, or we may decide that there's a couple other things being done because I don't know if that's sufficient time for the evaluation to occur.
Mm-hmm.
And it's sufficient time for reunification therapy to start. But I think we'll have a better idea at that June date.
Mm-hmm.
And with regards to my weekly access to my children, I have 1 hour on Wednesdays of FaceTime.
Mm-hmm.
Moreover, I have 1 hour on the weekends for a supervised visit.
Yeah.
Are those still going to be in place?
Those are still in place.
Okay. Is there any expansion to the FaceTime that we can add with 2 children on FaceTime for an entire hour, only 1 time a week, as the respondent can
I
also
agree with
attest?
you.
It's difficult to hold their attention.
I agree with you. It's not enough. We'll see what happens on the June status conference. I may sua sponte expand it then. I'm not expanding it right now.
Okay.
Again, importance of reunification therapy, importance of the psychiatric evaluation. Those are 2 really crucial things for me to look at. I want to expand it, but can't do it right now.
How long does the evaluation take? What's the time frame and
You know,
turnaround of
yeah, I can't give you a time frame of that, and that's very simply because that's going to be very different and very dependent on what the concerns are. For some people it may not be very long. For others, it may be a little bit more thorough. I don't know what it's going to be like for you, but even if it's just started, even if it's not complete, but I hear reunification therapy is going and it's going well, then we can even talk about expanding supervised a little bit more right now until we get to trial, where unsupervised is going to be on the table.
I hope so, because if that's not on the table, I have no light at the end of the tunnel.
You have light. You have light. And again, I'm going to tell you what we're trying to do here. We're trying to reunify you. We really are. It may not end up being what you want, which is 50-50, but our attempt is to try and get you to unsupervised.
And we're also attempting to help the respondent have keep her same style of lifestyle, though, aren't we?
Well, financial issues are part of a dissolution proceeding, and that's where you all are. So, all right, Ms. Bergman, is there anything else that we need to discuss today? And I do appreciate your, I appreciate your willingness to work with us, especially because this was the trial date.
That's right. We were supposed to have an end to this today, Mr. Arell, so that there would not even have been a need for the hearing on the 28th. It would have all been resolved today.
Okay, we got it, Ms. Bergman.
Yeah.
Your Honor, I'm sorry for the interruption, Ms. Bergman. Did you want me to schedule the status conference for the 28th? Or did you want Cheyenne to?
It's going to be part of the order. Cheyenne will take care of it, Melissa.
Okay, no problem. Thank you.
I guess, again, part of the last order, Your Honor, was that all the financial obligations would remain in place. And
they still do.
They still do.
They still do. And just the same, the orders are going to,
just keep adding up. That's another concern of mine is.
Yeah, it does. And that's why we need to
She's owed over $20,000 of spousal support, and then she's going to get the $100,000. She's going to have more money than she can claim to currently.
Ms. Orell, I think you're misinterpreting it. Again, this is why it's very important, if you can and if you want to try and seek representation.
Can the court please remind me of Mr. Schneider's responsibility and what he had given to the courts? He did absolutely nothing but take over $10,000 from me.
That's between you and him?
Absolutely nothing.
Okay. That's between you and him, Mr. Orell. I don't have any insight into what your attorney-client relationship was with him.
Well, I'm gonna seek Mr. Chandler's help on this. If he'll take me as a client, either him or the men's advocate rights up in Fort Myers. I did speak to them as well.
Wonderful. So I'm glad you're.
I understand I need representation, but that doesn't reassure me that the representation that I'm going to pay for with the money that I don't even possess right now is going to be beneficial, having gone through 3 different counsels.
Well, at some point, you may also want to think about the fact that if you're getting the same advice from 3 different people, and I don't know what that advice is, probably the advice from the 3 different people is correct. Probably.
I don't know what that advice is.
I don't know either because I didn't receive it.
The only advice is we can't do anything, Dave. You have an injunction. The injunction.
Well, you can let them know what I've just said, which is we're literally trying to reunify you, and a lot of things are on the table, including unsupervised time sharing at this trial.
We've been through 3 trials, have we not? Is this the 3rd one?
No, this isn't we were supposed to be a trial, but we haven't done the trial. We did the trial. We started the trial last time.
Yes.
But Ms. Bergman agreed to basically continue it because we all recognized the importance of getting
how much claims she needed. It was money. Money's holding this.
No, money's not holding it up. It's reunification with the children that's holding it up. If it was just about money, I would have continued with the trial the first time we were there, and we'd be done with the judgment, and we'd be done. This is about you and the children. That's why we're here. I understand we're getting emotional, so I'd like to resolve the rest of this today. Ms. Bergman, is there anything else that the court needs to consider right now while we're here?
Is there anything else, Stephanie? You're still living with your.
You're still on camera. If you want to talk to your client on mute, you can do that.
Well, no, I'm just everything else. Everything else is still the same. You're still in the same place. You're still living with your sister. You're still borrowing a car, and you're still getting the children to the Family Resource Center, and everything is and making sure everything is going to happen with the reunification therapy and
your belongings, your personal belongings.
Hold on a second, Mr. Arell. Hold on a second, Mr. Arell.
FaceTime, yes, right? Okay.
Yeah.
Is there anything that has arisen that the court needs to know? I don't believe so, but one last chance here. No? Okay.
Okay. Mr. Arell, is there anything else that we need to discuss before we meet again?
I have a serious obligation with this financial support. I feel that something needs to happen relatively soon with the amount of temporary support she receives on a monthly basis with regarding the car. For instance, her car, CarMax has taken me to court for $22,700. I cannot provide her a car. I cannot provide her insurance. I cannot provide her with anything currently.
Okay. Well, I understand what you're saying. That's not before the court here today. It would have been before the court if we were doing a trial where I could have made permanency determinations. Right now that would have been very difficult to make. One, because you didn't show up until 50 minutes after we started.
I understand.
And two, there's not much in the way of exhibits or anything before me that would have probably had me change what the temporary was, especially knowing that we're sitting on a lot of equity in this house that I understood was going to be sold.
I've submitted all my debt to the courts. You should have exhibits as long as my arm, considering the amount of debt I'm in. I'm over $150,000 worth of debt.
Okay. All right. Mr. Arell, is there anything else today that we can discuss? All those issues you just mentioned would be just determined at trial.
Well, with that being said, with all those other items, the only other item that I think that could be important would be related to the walkthrough here. Does it need to have a walkthrough here on the property? If she's not worried about the kids' belongings, which it appears that she is not laying very much importance on that. It's all about her going forward and her getting the things that she needs, not necessarily the children, because we're talking about the children here and not the response.
We're not just talking about the children, it's you both in a dissolution action.
So do you need to have it here on the property, or can
Yes.
I just take the things that she wanted and drop them off at Mrs.
Well, let me tell you this. There's nothing that's stopping you from giving her or bringing to Miss Bergerman the stuff that she desires. She doesn't need to do a walkthrough for that. You could do that today if you wanted
Yes,
to.
I know.
But she's still going to get the walkthrough. It's in a court order, and that's definitely going to be happening one way or the other.
That's fine. That's fine. I was just thinking I could help and speed some things up.
You definitely could.
If she had specific items in mind and not just wanting to come here and see what I have, basically.
That's definitely, again, not what's happening. And she has listed specific things in mind. She's been extraordinarily specific. The best thing you could do would be to get those things. You could get them over to Miss Bergerman right now. Maybe if you got them all over to her, she
I
would
have
say,
everything
I got
packed up
I
nice
got
and
everything. I don't need a walkthrough. That's possible. I don't know if that would happen.
I also
that's
have
possible.
a trailer full of kid stuff, but I guess I'll store that stuff and just bring Stephanie's belongings in. And I know it's not going to speed anything up because we already have a court date, and that's fine. That's
Okay.
I don't want to waste any more of the court's time about it.
Okay.
And the documents that we also requested, there were a very few of them, but there were just a few that we had requested about the the debt that he had at a certain time. That was in our subpoena for trial. We still are requesting that the next time we come back. We still have those. We need to know what the mortgage was at the time of the marriage, and we need to know obviously what the mortgage is when the house sells, but we don't have
I have submitted all that. All the TIAA paperwork has been submitted to the courts numerous times.
It's supposed to be.
All right. Well, Ms. Bergman, if there's a list of things that you need that you don't have, if you want to put it in a motion, we might have to hear it.
I just want what I had in the original trial subpoena.
Your subpoena tactum had been sufficed. I submitted all TIA paperwork and CarMax paperwork. Those are the two statements that you requested.
Mhm.
And I have updated those from as soon as last week. I had given you the most recent.
Okay. Well,
All right.
perhaps you might be able to email me just those two things again, Mr. Arel. That would be very kind.
CarMax and TIAA mortgage. Is that correct?
Yes. From two different, well, the most current mortgage and the mortgage from the date.
It'll be 3
That's it.
considering another entity has consumed the mortgage.
Okay.
Okay.
Because I,
All right.
yeah. So I'll send them over to you today, even though they've,
Wonderful.
I believe
Thank
they
you.
have been
Thank you,
submitted.
Mr. Arel. Thank
Yep.
you. All right. Thank you both very much. A special thank you to you, Ms. Orel, for obviously recognizing the need for reunification and allowing us to put off the trial here today to be able to do those things. Mr. Orel, best wishes to you as you embark on reunification. And I'm rooting for this family. I'm
Thank
rooting
you.
for this family. All right. We'll see you all soon. Thank you.
Thank you.
Thank you.